Hi everyone, we are delighted and excited to have you here and be a part of your journey to exam success. I am Ngozi Emmanuel and I oversee all administrative aspects of the NCA Guides. Before we dive into the review proper, permit me to give a broad overview of who we are and what we do. The NCA Guides is a registered partnership of 5 seasoned and experienced tutors who we also refer to as guides. We employ a guide approach because we believe that every candidate has what it takes to successfully challenge the NCA examinations, and our part is to guide the candidate to success. We understand the difficulty that the NCA examinations present, and we help candidates overcome the obstacles and difficulties in understanding the course materials and examination formats. We do this through intensive classes, revisions, and examination review workshops. We do not believe in a one-size-fits-all approach, and our study sessions are focused on helping candidates understand the course material in a way unique and personal to them. In addition, we also offer private and intensive tutoring sessions for candidates who are in need of a direct one-on-one session. If you are interested in registering for our private tutoring session, please reach out to us via email at inquiries@ncaaguides.com. Once again, I would like to say thank you on behalf of the NCA Guides team for joining us today. Please.
Hello everyone, my name is Sheun, spelled S-E-U-N. It's pronounced Sheun Smith. I'm the guide for Canadian constitutional law. If after this session or during the session you have questions or concerns and you'd like to reach out to me personally or privately, my email address is seun@ncaaguides.com. Right, I'd reiterate the fact that we expect that your cameras are turned on. It's going to be an interactive session. We've put this together pretty much for free to introduce you to the course, give an overview of the course, and torchlight or highlight areas that we think you should pay attention to when you study, right? So the list that you could do is abide by our ground rules, right? So please turn on your cameras except you have communicated a reason for not being able to. And then I'd like to ask, first ask if you've registered for the course, if you're certain you're going ahead with the course, and if you have started to study for the course. If you've taken a look at the syllabus, taken a look at the study materials, and where you're at with your study, right? Who wants to go first? Who'd like to go? Cherry Sofat, I remember you from my last session. Hi. Are you there? Are you able to talk? Hi, Ife. Have you started to study? Where are you at? Okay.
Hello? Hello? Can you hear me?
Yes, I can.
Okay, actually, I'm still awaiting my assessment.
Okay. That's good. Sounds good. Naomi, have you started? Are you done reading through the session?
No,
Reading through the syllabus.
yeah, I haven't gone. I'm like 40%. I intend writing in January, so I'm trying to see how fast I can cover. I actually need a lot of help, so that's why I'm here.
You started at least. That's impressive, right? Okay, so like I said earlier, it's going to be quite interactive, as you guys would make it, right? And then I also am approaching this with the mindset that a lot of people or a lot of the candidates on this call will probably haven't even taken a look at the study materials or and all of that. So it's not a test. It's not a compulsory. You have to give me the right answer, right? I just need some engagement to make sure that you guys have not just joined the meeting and walked away from your laptops, right? And then, of course, just general virtual meeting etiquettes. If you are unable to ensure that your space is quiet and not busy, then please mute your mics. I'd rather that your cameras are on, but then if your background is noisy, please mute your mics. If you have to talk, there's a hands up symbol. If I catch that, I will call you, right? But if I don't, please turn on your mic and interrupt me. I have no problems with people interrupting me because you realize that I'll interrupt you a couple of times as well. So I always advise candidates to take a look at the syllabus for all the NCA subjects or courses. Take a look at your syllabus, read through it, right, and let that guide your study, right? For constitutional law, there's not really a lot going on the syllabus, but doesn't hurt to take a look at it, really. And then it's going to be the guide for this session. At the very least, we'll refer to it for the chapters, and then I'll try to go chapter by chapter. We'll see how much, we can smuggle into this 2-hour room that we have thereabout, and then just give a very short, concise, brief over what I, believe that you should pay special attention to when you start a study, and what we will be getting into if you decide to join our paid classes, right? So I will give a couple of minutes for you to pull up your syllabus. If you don't have it printed out, just go to the NCA website, nca.legal, go under exams, and you see outline and syllabi, and then you'd see exam outlines and samples, right? You click on that, and then you scroll through the list. You see Canadian constitutional law under exam outline and syllabi, and then there you have the syllabus for Canadian constitutional law. Of course, the recommended text is contained in the textbook. In the syllabus, and there are also a number of notes that are summaries of the recommended text. At the Ncaa Guides, we recommend Manuel Akinshola's notes. We have it for sale on our website, but please feel free to, preferably the textbook. If you're scared of the volume, or you believe that you cannot afford it for now, there's summary notes all over the space. And we recommend Manuel Akinshola's. If you pay or you decide to sign up for our intensive classes, our paid classes, I have prepared very concise notes. Some are one pages per topic. At the most, you probably have 3 pages per topic. Of course, that should not be, that wasn't intended to be your basic study material. It's just a concise, maybe take into the exam hall. It'll guide our conversations at the intensive classes, what I consider salient points, relevant to each topic, right? So we'll start the conversation with chapter 1. First of all, as a way of introduction to the course, Canadian constitutional law, just as it sounds, is a course that intends to or aims to understudy or underscore the constitutional law framework or landscape of Canada. It's safe to assume that everybody on this call, everybody that is an NCA candidate, most likely has been called to the bar in some jurisdiction, and you have had to study or underscore the Canadian, or rather the constitutional jurisprudence of a particular jurisdiction, right? So it's pretty much the same here. We're just trying to see what is the Constitution in Canada, right? Identify what the Constitution of Canada is, and then zoom into it, highlight areas that play a very pivotal role in the way the systems of government in Canada are administered, are run, right? And then, yeah, pretty much that's just set your mind up that way, because I know that for a lot of candidates, when you open the materials, you see the first chapter, usually you close it right back because it pretty much looks like Greek. But set up your mind getting into your study that way. It is just, you trying to understand what the Constitution in Canada, or Constitution of Canada, is all about, how it affects governmental actions, what role the courts play in giving life giving effect to the Constitution and making sure that, you know, governmental actions, legislations in Canada are consistent with the Constitution of Canada, right? Does that sound good? And then the first chapter is the sources and the nature of the Constitution. Like any jurisdiction in which you underscore the Constitution of that jurisdiction, you have to pay attention, do a bit of history, pay attention to what has informed the Constitution of that country, right? What are the sources and what is the nature, right? Under sources, you're talking what has informed, what has contributed to, you know, this document or set of documents that are called the Constitution, or this jurisprudence, body of laws, you know, rules, principles that are considered or that have been given constitutional status in a country, right? That's what you talk about under sources. For nature, you're talking pretty much, is it written, is it unwritten, is it found in one single document? What is it like? What is the form that it assumes? So for Canada, right, we're all, I assume, familiar with the fact that Canada was also colonized by Britain. And, you know, for a while, the Privy Council in Britain legislated and pretty much governed Canada. And then there was the BNA, right? The BNA Act, which later metamorphed into the Constitution Act 1867, right? Very important document. You find out soon as we go along that for the purpose of this course, you need to pay very close attention to two documents: the Constitution Act 1867 and the Constitution Act 1982. Right, so the BNA morphed into the Constitution Act 1867, and for the purpose of this conversation or your study of this course, all you need to know, or you need to pay attention to at this preliminary stage, is that the 1867 Constitution Act is very important because it provides for division of powers, right? That is the Constitution Act that makes provisions for division of powers, 1901 and 92. But just before we get into that, right, let's still review the Constitution in and of itself. So we have the BNA that morphed into Constitution Act 1867, and as time went on, Canada and the Britain decided that it was time for Canada to get some liberation from Britain, and then the Constitution Act 1982 was passed, was enacted, right? And a very important highlight or features of the Constitution Act 1982 is that, of course, like I said earlier, it really marked the beginning of Canada's liberation, you know, absolute self-governance from, in the real sense of the word, right, from Britain, so that the 1982 Constitution now provided for amending procedures. Before 1982, even though, you know, there'd been some negotiations and back and forth about Canada's liberation and ability to enact laws for itself, it could actually enact laws, it did enact laws for itself, but Britain still held the power to amend a constitution, such that if there was any issue, constitutional issue that Canada needed to amend, you know, based off of the 1867 Constitution Act, Canada will still have to revert to the Privy Council. The Privy Council will have to sit and then amend the Constitution. But very important feature of the 1982 Constitution Act is that now Canada, you know, had amending procedures that it could implement or apply to amend its constitution on its own without consulting the Britain or the Privy Council, right? Very important highlight. Another important highlight of the 1982 Constitution Act is that it also introduced civil liberties, right, called the Charter. Very important. We're going to review that in very fine details. The Constitution Act 1982 also provided for the Charter, right? And then another important highlight of the 1982 Constitution Act is that it entrenched Aboriginal rights into the Constitution. It gave Aboriginal rights constitutional status in Canada. Are we good thus far? So for the 1967 Constitution Act, or rather 1867 Constitution Act, I have mentioned that the probably the most important feature of that document for the purpose of our discourse is that it provides for division of powers. Section 91 and 92 provides for how, you know, legislative powers in Canada would be administered, would be exercised. That is 1867. 1982, three things. It provides for amending procedures, which was the hallmark of, you know, liberty, Canada's liberty for liberation from Britain. It meant they didn't have to, you know, make recourse to Britain to create laws or to enact laws, right, or to amend the Constitution. First, secondly, it provided for the Charter, right? The Charter was introduced, and the Charter pretty much is civil liberties. In Nigeria, I know that we call them fundamental human rights. I'm not sure right now what it is called in jurisdictions like India or other jurisdictions, but pretty much that's what the Charter is about, just civil liberties, rights and freedoms, human rights and freedoms, right? And then thirdly, it entrenched or it elevated Aboriginal rights and, you know, conferred constitutional status on Aboriginal rights, right? Now, it's important to note, once we're talking about, still talking about the nature of the Constitution in Canada, it's important to note that there is not one single document that makes up the Constitution of Canada. I mean, just from this conversation, we have highlighted two separate documents. We've highlighted the Constitution Act 1867, highlighted the Constitution Act 1982, and there are a number of other documents that make up the Constitution Act, right? Or that make up, rather, the Constitution of Canada, right? When we come into the intensive classes and we're studying in better details, we review the sections of the Constitution that attempted to define the Constitution. You see how that section used the word includes, and how that word includes have been given or has been given a judicial interpretation that means that, you know, the list that followed the word is not exhaustive or final, right? So there are a number of other documents, a number of other, you know, principles that have been elevated to constitutional status that form part of, you know, the Constitution of Canada. So that pretty much speaks to the, it's not unwritten like you have in Britain, but it's not contained in one single document like you'd have in a lot of other jurisdictions like Nigeria, right? So we can move quickly into the sources of the Constitution of Canada. Having established that the Constitution of Canada is found in numerous documents, right? That it's not contained in one body of work or one document. You can imagine that, you know, a number of things will speak or will pass as a source of, you know, the Constitution, right? First, we'll talk about Imperial Statutes. I'll just give one-liners. I'll highlight the sources, give one-liners, and then we can move. I'd like to reiterate before I proceed that your cameras need to be on, except you absolutely cannot have them on, in which case we usually demand that or request that you send us an email to explain why they cannot be on, right? Cherry, I'm still waiting for you. Whenever you can, turn on your mic to just pitch in. I'd just like to hear your voice because I remember you from my last session. Okay, so we have the Imperial Statutes, as now we're talking about sources, right? And the Imperial Statutes are pretty much like it sounds, Imperial Statutes that were enacted by Britain when Britain was still played a very major role in the governance of Canada, which would have been during the colonization era, right? And then some of those statutes, about 17 of them, have been retained and, you know, have had the constitutional status conferred on them. For the purpose of the NCAs and the exams, you don't need to bother yourself about what those statutes are. Just know that Imperial Statutes are a source of constitutional law. Are we good? Right. Another thing that we can call a source, or another source of constitutional of the Constitution in Canada would be case law. Very important. Right. Whilst we're clear, I mean, we all have a basic understanding of how the three arms of government work: the judiciary, legislature, and executive. Even though I must say before I proceed that you need to almost disabuse your mind from what you knew from what jurisdiction you had studied law, because it works a bit differently. The subtle differences in Canada with the interaction of the three arms of government in Canada. But I mean, it's basically the same thing. The executive executes laws, implements laws, the legislature enacts laws, right? And the judiciary interprets and gives life to those laws, right? So case laws, I mean, whilst we know that the judiciary doesn't enact laws, we know that they interpret laws, and then we know that from our study of, law, we know that there's schools of thought that believe that actually the laws are what the courts say that they are, right? Laws that take the form that the courts give them in whilst discharging their interpretation role, right? So it becomes important that, I mean, case laws play a very important role as a source of Canadian constitution, or rather play an important role as a source of constitutional law in Canada, right? We'll review cases like secession reference, if whilst you're studying, if you don't come to the paid intensive sessions, but if you do, those are cases that we will review in fine details. If you do not, whilst you're studying, pay attention to those cases. Secession reference, cases like judges' remuneration, where the court highlighted that independence of judiciary is a constitutional principle, though unwritten, right? But elevated independence of the judiciary to, assume constitutional status. Secession reference, where a number of other principles were highlighted: democracy, protection of minority rights, federalism, were highlighted, and given constitutional status in Canada, right? That's pretty much how case law speaks to the jurisprudence of constitutional law in Canada, and how the judges or the courts in interpreting laws or in adjudicating cases or reviewing references that are being directed to the courts have contributed to the landscape of constitutional law in Canada, right? We've highlighted Imperial Statues, we've highlighted case laws, royal prerogative, pretty much just the fact that even though Britain is out of Canada, not particularly playing any pivotal or obvious roles anymore in the governance of Canada. However, the residual powers that Britain had, right, just like it sounds, royal prerogative, that the Crown still retains in Canada, right, and have been elevated to constitutional status. We'll review those as well in details. Off the top of my head, an example I'll give you is it will be diplomatic relations, right? Canada's diplomatic relations, the conferment of honorary titles and awards, right, within Canada. Those are still reserved or retained by the Crown, by Britain. And then we'll look at parliamentary privilege as well as a source of constitutional law in Canada. Parliamentary privilege is, the way I like to explain it to my candidates is that, as we've established, Britain colonized Canada as well, right? And then there's the very obvious or strong similarities between the system of government being operated in Canada and that being operated in Britain, even though they're divergent points, but there's also points where they converge and they're similar. One of those instances would be the Parliament, or the fact that Canada mirrors Britain's parliamentary system of government. Now, whilst the constitution in Canada is supreme, right, and Canada practices constitutionalism, which pretty much means that the constitution is supreme, it's the ground norm, and governmental powers and laws have to conform or have to be consistent with the Constitution of Canada, right? So that is up here, but just right beneath it is the parliamentary system of government. The fact that the Parliament is supreme, well, is supreme next to the Constitution. And even though we say that the Parliament is supreme next to the Constitution in Canada, it is important to note that certain privileges that the Parliament enjoys still today are still not required to conform to the Constitution, cannot be reviewed by the judiciary, right? So that also comes in and plays a role as a source of the Constitution, because if something has been elevated or something has been declared not to be subject to judicial review, it means that it is at par with the Constitution, right? So parliamentary privileges are at par with the Constitution. They are a source. They speak to the constitutional jurisprudence of Canada. We will review it in great details, highlight samples or what examples of parliamentary privileges and how they operate. We'll review a case or two that will help us to see the highlights, when they're reviewable and when they're not, the differences, right? When parliamentary privileges can be looked into by the court and pronouncements can be made by the court, and when the powers of the courts are completely ousted in, the review of parliamentary privilege. So pretty much that should sum up the conversation for chapter 1 in terms of the sources and the nature we've highlighted. We've had a brief conversation on what the form or the nature of the Constitution of Canada is, and we've also highlighted a few of the sources of the Canadian Constitution. Any questions before we move into chapter 2, when we have to move with the speed of light? Right? Can we go to chapter 2? Any questions? Okay. Do you have your syllabus? What's the next chapter? Who's going to help me with what the next chapter is?
Amending procedure.
Yeah, amending procedures. So pretty much what I like to say to my candidates with amending procedures when you study is print out the sections 35 to 45 of the Constitution Act 1982. Print them out if you can. It's not bulky, it's not voluminous. Print it out and read those sections. We will be reading them in class, and then that will form the prelude for whatever conversations that we will be having, right? This is a chapter that doesn't have a lot of case laws to speak to, so you cannot, I believe that case laws make legal principles a bit more, they make them animated, they make them come to life, right? So you can see how it operates in real life or how it works in real life. But this is a chapter where there's pretty much zero case laws, right? So read the sections, and then it's clear that the Canadian Constitution is not drafted in archaic English like the Constitution in some other jurisdictions. It's very clear, it's plain simple English, but you need to read it yourself, right? Because there overlaps, or not overlaps, but things that appear to be overlaps, right? That I find that gets candidates confused. But that is just a tip and my advice, right, to help your study. If you come for the paid classes, we'll certainly read them word by word, read those chapters word by word. But as a way of an overview, there are about 5 amending procedures. I've given a brief history of how this came about and the significance of the fact that the 1982 Constitutional Act provided for amending procedures, right? But as a way of a brief overview, there are 5 amending procedures. There's the general procedure, which is also called the 750 procedure, right? There's the Unanimity Rule. There's the some but not all provinces rule. There's the federal parliaments only, and there's the provincial legislative assemblies rule only, right? And then those sections, the relevant sections, are pretty much highlighted instances where what rule will apply, right? So for the 750 rule, you find that important issues, right? Pretty important issues that touch on the whole of the entity called Canada, right, come under the 750 rule. And what the 750 rule means is that, for this matter in the Constitution to be amended, we need a majority. In Canada, there are 10 provinces, a majority of 7 out of the 10 provinces to vote in favor of that amendment. And not just 7 out of 10 provinces, those 7 provinces must make up in terms of numerical, not in terms of the numerical representation in Canada's population, they must make up at least 50% of the population of Canada, right? That tends to get candidates confused every now and then, but we'll review it in finer details at the intensive classes, right? So that's the 750 rule. And then you have the Unanimity Rule. As it sounds, it means that all 10 provinces must agree to the relevant amendments before it can be given effect to, right? So that already tells you that the issues that come under the Unanimity Rule have to be issues of utmost importance, right? To require that all 10 provinces concede, right? And then you have the some but not all provinces. That just as it sounds, it just means that if the provinces that are affected, or that will be the most affected, are the ones that are required to vote, right, or to express their opinions, right? Then you have the Parliament only. Those are issues or instances where the federal Parliament can single-handedly amend the Constitution. And then lastly, you have provinces alone. So those are instances where the legislative assemblies of the provinces can single-handedly amend their Constitution. And, pretty much that's a conversation to have on chapter 2. I have it all in a page and a paragraph, right? Just to give some form, some guidance, some structure to your study. And then when we get into the intensive classes, we'll have more robust and productive conversations with respect to those amending procedures, right? And that pretty much takes care of chapter 2, if you ask me, except their questions. And then we move to chapter 3. So somebody needs to tell me what the third chapter is, if we're looking in our syllabus.
Federalism.
Federalism, thank you, Bingping. So federalism, I always find that the bulk of candidates are familiar with federalism because we pretty much all run some form of federalism in our countries, right? So I don't spend a lot of time trying to explain and define what federalism is, right? It's just the fact that in the case of federalism, executive powers are divided between usually a central and regional governments, right? That's federalism, right? As base as it sounds or as it is, right? But I like to highlight, or I'd advise, when you go to study, when you start your study, that you pay attention to, first, the reason why Canada assumed or adopted federalism as its system of government, right? And to speak to that real quickly, it's just the fact that, Canada is so multidimensional, multicultural, bilingual, right? And so it makes sense that there is not one cohesive, government at the helm of affairs for Canada, right? If you go back in time, do a bit of history, you see how different territories, came in and negotiated or expressed their desire to be part of the entity of the Dominion of Canada, and how they negotiated. This is what we used to do when it was just us as a territory, and we hope that we can retain some of this, systems and structures, even though we really would like to be part of this Dominion of Canada, right? So it was important that the system of government that would be adopted would be one that could still give significant autonomy to the provinces or to the territories that were coming together to form the Dominion of Canada. So that's one of the reasons why Canada adopted the federal system of government. Now, so yes, highlight or pay attention to the reasons or the things that informed the decision to adopt federalism in Canada. Pay attention to the difference, right? The distinction, because Canadian federalism is distinct, right? Pay attention to that. This distinct in comparison to, the version of federalism practiced in a number of other jurisdictions that practice federalism, right? So pay attention to that distinction, very important, right? When I was writing my exams, I got a question out of the blues from nowhere that spoke to that, or that required you to know that. So pay attention to that distinction, what makes Canadian federalism worth studying, right? And then pay attention to judicial interpretation, pretty much the role that the court plays in Canada's federalism, right? And that's nothing spooky. That's pretty much just what it is with other jurisdictions that practice federalism, across the world. The fact that there needs to be an arbiter, a neutral arbiter between these levels of government that executive powers have been divided between, right? So that the court now comes in to say, oh, federal government, you cannot do this. State or provincial or regional government, you can do this, right? So pay attention to those, the reason for federalism in Canada, the distinction of the Canadian federalism, right? And then the role of the courts in Canada's federalism, the principles of judicial interpretation that have been adopted by the courts in interpreting and reviewing and giving the structure that Canadian federalism has as of date. Right? Any questions? Any issues? Can we move? Right, chapter 4. This is where the gist of the cost, the real meat begins. And somebody, I need to please turn on the camera. I mean, I cannot make this as engaging as I'd like for it to be because the bulk of you say that you haven't really studied, which is okay. But at least you can help me with the chapters that we will be discussing, right? So what's chapter 4 on the syllabus?
Judicial review and principles of interpretation.
Okay, thank you. Judicial review and principles of interpretation. I mean, we're spoken a bit to that in chapter 3 when we're talking about federalism, right? But I'll just real quickly explain what judicial review is so that when you go into your notes or your textbooks, it doesn't sound like Greek. So judicial review, as it sounds, is just the court's powers, constitutional duty, obligation to critically examine for the purpose of determining, the constitutionality or otherwise of either an action or a law, an act, a governmental act or legislation. That's pretty much judicial review. Judicial review by the judiciary. And review pretty much is just a critical examination, what are the components, what's the nature of this issue, right? And what was the intention of the key actors, and do all of this summatively or cumulatively align with the letters and the spirit of all the very different components of the Constitution of Canada. That's judicial review. Principle of interpretation, like we have said, is how does the court, or what principles have the court laid down, and are generally accepted by the judiciary as, the guides or the aids that help the court in interpreting legislation, right? Now, that's pretty much me trying to explain what those two concepts are, but it opens up into a very bulky conversation. The Studying Canadian Constitutional Law, chapter 4 particularly, so that you start to have we now look at, in fact, if you ask me, chapter 4 opens up the conversation for the rest of the chapters. It lays the foundation for the conversation that we'll be having from chapters 5 to chapter 20. So it's a very important chapter. It's very bulky as well. And it also has principles that almost always confuses candidates, right? Contained there in chapter 4. So I'll spend a bit of time on chapter 4 and then we'll fly through the rest of the chapter. So I've said that judicial review pretty much is just the court's, the constitutional duties or the constitutional powers, depending on how you choose to look at it, whether as a burden or as a benefit, right? That the courts have to examine, right, critically governmental actions and legislations for the purpose of determining their constitutionality, right? It's also important that you have at the back of your mind that the whole essence of this conversation is based off of Section 52 of the Constitution Act 1982, right? I would say someone should pull that up real quickly on their webpage, but you guys look like you haven't gotten into the mood yet. You all still look a bit sleepy, like what's this lady going on? But yeah, it'll be good if someone could quickly pull that up and let's read it, because that's what forms the basis of the bulk of the conversation that we'll be having with constitutional law, Section 52 of the Constitution Act 1982. Is someone on it, or do we move right on?
I can read it.
Please, thank you.
Section 52. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Okay,
so pretty much, I mean, we all have similar, at least I know that in Nigeria we have a similar provision, right? Any law that is not consistent with the Constitution is, to the extent of that inconsistency of no force and effect, right? And then we've established that it is the duty of the courts, you know, to undertake this review that would, you know, reveal the consistency of a law or a governmental action with the Constitution, right? So that's pretty much what Chapter 4 is about. So we open up Chapter 4, I mean, with this introduction, and then we get into what you know, you would find as being tagged federal grounds in your material, right? To make it clear, I always say to my candidates, once you say federal grounds, usually what should come to your mind more often than not, in fact, you know, I could authoritatively say that all the time, always, should be legislations. Once you see federal grounds, you know that what is being reviewed now or being interpreted now is a legislation and not a governmental action. So you find that with federal grounds, you know, what you're reviewing would be a legislation, whereas with charter, what you're reviewing more often than not will be a governmental action, right? Now, there could be a crisscross or overlap there such that a legislation could have informed an action, right? Or an action could be based off of, or the actor could claim that he you know, could base his action on a power provided by the legislation, right? But just as a way of making it clear, having it, maybe tabularizing it just for purpose of clarity, have that at the back of your mind that once you see judicial review on federal grounds, what you most likely will be reviewing for constitutionality is a legislation. And once you see judicial review on charter grounds, what you most likely will be reviewing is a governmental action. With charter, is a bit dicey because you could have legislation also show up there, but more often than legislation, with charter grounds will be actions. Did I confuse you? Is it clear? Okay. So we, yes, Ife, say that again. So you see, and I said that, right, for the purpose of exams and just for clarity purpose, for academic purposes, right? Once you see, say at the end of your question, Party A is applying to the court for a judicial review of, you know, blah, 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 on federal grounds. You know that what is being touchlighted there or highlighted there is a law, a legislation, a body of law, right? An act, right? Something acts, right? A law, a legislation, an enactment, right? And then once you see judicial review on charter grounds, more often than not, with the charter, you need to be a bit careful. The charter can be quite dicey, but more often than not, it will be a governmental action, right? Maybe the police has now finally arrested you, right? Or your application for a license has now finally been refused or denied. Then what will come to play there more often than not will be charter. Not fit, it will be a judicial review on charter grounds and not a judicial review on federal grounds. Are we good? Is it clearer now? Okay. So Chapter 4 opens up the conversation for judicial review on federal grounds, and I'll try to get into it as briefly as I can without confusing you, right? Because the essence of this is to give you an overview, a framework to base your reading on, or to get you to come to the intensive classes, right? So for the judicial review on federal grounds, what it is that you have a legislation, right? A body, or rather a level of the legislature has passed the legislation, either the parliament. We have established that Canada runs a federal system of government, and that means that there are two levels of government. In Canada, it's called the federal government and the provincial government, right? And we've also established that by virtue of sections 91 and 92 of the Constitution Act 1867, all legislative powers in Canada. Did we establish that on this call? If I haven't, let's establish it real quickly. I think I did whilst I was highlighting the feature of, you know, both Constitution Act, and I said that the most important thing to note about the Constitutional Act 1867 is that it provides for division of powers, right? Pursuant to sections 91 and 92 of that Constitution Act, it divides all legislative powers in Canada between the Parliament, which is the legislature at the federal level, and the legislative, the provincial legislative assemblies, which are the legislature at the level of the provinces, right? So you have two levels of government, right? And then I've also established that the parliament is kind of supreme, only next to the constitution in Canada. So the reason why we're highlighting legislative powers, right? So legislative powers in Canada have been divided between the federal parliament, the federal government, and the provincial government, the legislative assemblies, right? I'd also generally typically advise my candidates, if you come for the intensive classes, certainly you have to show me your printed sections 91 and 92. You absolutely have to print your 91 and 92. Take it with you to the exam hall or review it very intensely, internalize it before you go into the exam hall, right? So 91 provides for the parliament, I believe, and 92 provides for the legislative assemblies. So what that means is that legislative powers have been divided. It just means that when you read 91 and 92, what you will find there is that matters, they're called subject matters or heads of powers, where kind of like a list was kind of, created, and there was a tabularization. This is for the parliament, this is for the provinces, right? That's pretty much just the way it sounds, division of powers. The powers were divided, right? So you have criminal law belongs to the parliament. Property and civil rights for the provinces, that way until all the legislative powers presumably were exhaustively distributed between both levels of government, right? Such that the position in Canada is that there cannot be any new matter that will not have been divided or that will not have been provided for by the division of powers contained in 91 and 92, right? So that even if we admit that there's a new matter, there is an omnibus clause, provision both for the provinces and the federal government that allows them to subsume this supposedly new matter that, nobody knew about in 1867 when the Constitutional Act was being enacted. Is that clear? So exhaustively, all legislative powers exhaustively have been divided between the federal government and the provincial government in Canada, right? And so there cannot be any new matter that will cause a confusion or cause the recreation of another level of government who will now assume that power. Does that sound good? Okay, so chapter 4 now opens up the conversation of how the court, gives effect to this division of powers. Because, just from explaining it, you can imagine that there will be a lot of conflict, right? There will be a lot of, oh yes, Section 91 says this, but this situation also looks like that, and that is for the province. Do you understand the point, right? So chapter 4 just zooms in on how the court over time, since 1867, when this division of power concept was introduced by the Constitutional Act, over time have firstly interpreted these heads of powers. We say criminal law. What passes as criminal law? That was the example I gave initially, right? Criminal law has been Section 91 provides that criminal law is a federal head of power. It's competent only to the parliament. Now, this is an issue. For instance, a road traffic issue. Does that pass as criminal, right? Or would it just pass as, something that is internal to the provinces, right? So all the principles, all the tricks, and all the aids and guides that the court have over, the space of hundreds of years right, have applied and consistently stuck to, right, as what will help or what has aided them to interpret the Constitution, right? These heads of powers, the situations that are being brought to the court are the things that we would be understudying or underscoring in chapter 4, right? That's why judicial review and principle of interpretation. Now, real quickly, as an overview, I'll get into characterization and assignment. So a legislation comes to court either by way of a reference or a full-blown application for judicial review, where someone, a concerned citizen, is saying, the federal government has passed this law, right? Off the top of my head, regulation of fishery and, something act, regulation of fishery acts, right? And then a citizen has come to challenge the constitutionality of that legislation, to say O courts, it's your constitutional duty to review these laws and determine the consistency with the Constitution, right? Please review this new legislation that was enacted by the Parliament and determine if it is constitutional or not. Because I don't think it's constitutional. I don't see why this law should bind me, right? So that's how these matters get to courts. Or the governments themselves, maybe the provincial government. Somebody needs to mute their mics. It's fine to mute your mics. What I want on are your cameras, of which is just a few of you, a handful of you who have your cameras on. You can mute your mics until you have something to say. You have a question or comment. You can leave your mics mute or muted, but please have your cameras on. Okay. So, or the governments themselves, either the federal government or the provincial government, approaches the court by way of a reference to say, we're considering, enacting this type of legislation, right? We're in the process. Would like to have your thoughts. All courts, would this, if we enact this legislation, right, would they violate the Constitution, right? So that's the way these matters get to the court. And once a matter gets to the court that way, then the business of the court is to review the legislation, like we've established repeatedly, for the purpose of determining if it is constitutional or not. Now, what the court would do, real quickly, succinctly put, is that the court will characterize the legislation. And I know we're all coming from provinces or jurisdictions, rather, where legal terms sound one way but have been interpreted another way. But one of the things that I say to my candidates is, in Canada, things are a lot easier, particularly the NCA exams. It's not as spooky or as scary as, what you might have heard. You almost really can just interpret these terms using common sense and residual knowledge, right? So when I say that the court will characterize the law, it's just as it sounds. The court would try to determine what the main character of this legislation is, right? So this is this legislation. Yes, the title is Regulation of Fishery, like the example I gave, but the court will look into the details, the sections, the interpretation section, all the body sections, right? Everything about the document, about the act or the statute, for those of determining whether it really is in relation to regulation of fishery, right? Sometimes in characterizing the law, the court would decide, though you title the regulation of fishery, it really is in respect to the commercialization of fishes. Do you see that, right? Whilst embarking on the review exercise, though this legislation is titled this, having reviewed the content of the legislation, the effect, the purpose, right? We are decided that the character of this law has no bearing with the title, right? So that's just what characterization is, trying to determine the pith and substance of a law, trying to determine the most prominent feature of the law, right? Trying to determine the essence, right? What can be declared to be the core feature, core substance of the law, right? Because if the court cannot determine that, then it becomes impossible to assign it under Section 91 or 92, right? For the purpose of determining whether the body that enacted the legislation in fact had the constitutional authority to enact it. Are we clear? Are we clear, right? Do we understand, at least to an extent, the meaning of division of powers, right? And the role that the courts play, when it comes to judicial review on federal grounds for the purpose of determining the constitutionality of a legislation. So there's characterization, the first step of the two-step process. Characterization, the court tries to determine the essence of the law, the pith and substance of the law, the most important subject matter of the law. And then once that is gleaned out, once that is distilled, then the court assigns it or classifies it under either of sections 91, right, or 92. And then the result is that if it falls validly within the competence or a head of power of the body that legislated it, then it is constitutional, right? But if it doesn't, for instance, the example I gave, the Parliament has enacted Regulation of Fisheries Act 2007. The court, in characterizing it, like I said earlier as well, has determined that even though it was titled Regulation of Fishery, it really, in fact, is, concerns the commercialization of fishes, right? So the court decides that if this is the subject matter of this law, then the Parliament has no business, regulating that, right? Because it is only competent to the province. Selling of fish is, do you see that? And so that will inform the court's decision to pronounce it unconstitutional. And if it's the other way around as well, conversely, if the court agrees that, okay, it really is in fact in relation to regulation of fisheries, and the court reviews 91 and 92 and determines that regulation of fisheries is really under Section 91, which is the competence of the Parliament, and this act was enacted by the Parliament, then the court would declare, that it is constitutional. Are we clear? Anna, are you good? Do you want to say what I just said right back to me in your own words, please? Do you want to tell me what you understand by division of powers and how the court, what role the court plays in division of powers in your own words, just so I know that we're good? Real quickly.
Okay. Division of powers essentially is how powers of legislation are divided among federal and provincial authorities. So there are certain things, kind of like what we have in our own constitution, there's exclusive, associate, and concurrent as well. So there are certain things in the constitution which the federal parliament is required to exclusively legislate upon, as well as those that provincial governments are also required to exclusively legislate upon. As for the court's role in this, you asked, I'm not sure.
Okay, great. Thank you. Who wants to speak to that? The role of the court in, what the court does in conducting a judicial review on federal grounds.
So, from my own understanding and from what you've said, it looks like they do judicial review of matters that come before them, and they are two-step process. I think that's what you said. So first, they determine from the facts if that matter actually, they determine what the substance of that matter is. Then when they find what the substance is, then they characterize it under the heads of power. And if it falls under the heads of power of, say, the Parliament, then the Parliament made the law, then it's constitutional. But if it falls under of the provincial legislative body, and the Parliament made that law, then it's unconstitutional because it's not.
Thank you, guys. Thank you, Anna and Naomi. I feel better now. Okay, so pretty much that's pretty much what it is, right? Like Anna said, pretty much what division of power is, and like Naomi said, the role of the court in conducting a judicial review. However, I'd like to highlight, Naomi, when the court is, like I said, once you see federal grounds, it usually is a legislation, right? So not just a matter like, oh, somebody did this, that, like a regular, court case. Here, it will be an impugned legislation. It will be a legislation that is being impugned or challenged, right? To say this particular legislation has been enacted, right? And then I'm not comfortable with it. I don't believe it's constitutional. I don't believe I should, it should be binding on me, right? So please review this legislation, dear courts, right? So usually it's a legislation, right? And then characterization is the first step in the process where the court is determining the character of the law, right? And classification or assignment is the second step where the court, having determined the character of the law, is now assigning or classifying it, to determine if the enacting body is actually competent or was actually competent to legislate in relation to that specific character of that legislation. It's a bit of a mouthful, but that's what the principle is, right? So just to reiterate and drive it home some more, if Semirat is by virtue of Section 91 of the Constitutional Act 1867 is competent to regulate, or rather to enact in relation to regulation of fishes or regulation of fisheries, like my example, right? And I mean, it's just an example off the top of my head, right? Semirat is the parliament. She's supposed to legislate in relation to regulation of fisheries for whatever reason, for conservation purposes, right? So that, you know, all the fishes in the ocean do not get depleted, right? And then Ife is, if I'm not calling your name, it's because I cannot see your face, right? I can only, it's just the people who I'm saying I feel like I'm engaging, right? And Ife is the province, right? Under Section 92, she's competent to regulate commercialization or sale, buying and selling of fishes within her province. Say, for instance, Ife is the province of Alberta, right? And then Semirat has enacted this Cover Girl legislation, Regulation of Fisheries Act 2007, which proposes to regulate fishery, right? You can sell, it's not our business what you buy and sell, right? But you cannot sell more than maybe 8,000 tons of fish per year, right? And then maybe Ife, again, the province, usually it could be the province, the government themselves coming to the court by way of a reference or by way of a full-blown challenge, or just somebody in the fishing industry, right? Maybe Anne says that I went to buy fish from my supplier today, and my supplier says the federal government has enacted a law that says they cannot sell fishes to me anymore, right? And then she approaches the court to say, what's this new law about, right? And then the court is now, you know, there's now an application before the court to judicially review this Regulation of Fisheries Act 2007. Is that good, right? So the two-step process, first, characterization. So the court demands for the act. Can I see this Regulation of Fisheries Act 2007? And reviews everything in fine details, not just the title. You know, those are some of the things we will get into during intensive classes. And if you choose not to be a part of the intensive classes, during your private study, pay attention to the things that the court will look at in characterizing a law. The court will look at the effect of the law. What effect is it having? You know, is it impacting commercialization? Or is it impacting commercialization more than it is impacting conservation? Do you understand that? What's the purpose, right? Yes, you have titled it Regulation of Fishery, but really, what were your thoughts? What was the intention of the Parliament when the Parliament was enacting that law? For that purpose, it's been held that the court has the jurisdiction to call into evidence the pre-legislative history of that legislation. And what pre-legislative history just means is, you know, papers that speak to when what conversations were going on the floor of the House, in this case the Parliament, when that bill was being, you know, deliberated on, right? So the court looks at all of that to determine the intention, the purpose. Sometimes if you have it as an exam question, the fact of the question will include something about how the Federal Minister of Conservation, or, you know, something like that, has, you know, went on the news and said, oh, they're just buying and selling. We don't even know how much they're selling. We don't know. Do you understand? So all of that as well, admissible in evidence. You know, from them, the court is able to glean what was the intention, the purpose of the Parliament whilst they were enacting that legislation. So the court reviews all of those holistically, you know, and then determines that we're not convinced that this legislation was in fact for the purpose of conservation, right? We think that it has more effect in regulating the commercialization of the sale of fishes, right? And that is competence to Ife, province of Alberta, right? So all parliaments, you have enacted a legislation in relation to a subject matter that is not competent to you, right? That is in relation to a subject matter that is competent only to the province, only to Ife. For that reason, this legislation is not constitutional, right? So two-stage process, characterization and classification or assignment. Does that sound good? Right? So that will take us real quickly into the conversation of, once you start a study, you see a principle called the pith and substance doctrine. And that pretty much is what the pith and substance doctrine is, what we've been talking about, particularly characterization, right? In characterizing, the pith and substance doctrine says that, you know, of course, you determine the pith and the substance. The pith is PITH, and I believe that, you know, that's the word for the big round seed in the middle of an apricot or a peach, right? So, like, what's the core, you know, of this legislation, right? What's the substance of this legislation, right? And the pith and substance doctrine says that the fact that a legislation, you know, incidentally touches on some other subject matter that is outside of the competence of the enacting body will not make that legislation unconstitutional. So we're getting into a bit more depth, and I really need your attention because it gets a bit dicey going on forward, right? We've established a general rule. The court determines the pith and substance if it is a subject matter that is competent to the enacting body, then it is constitutional. The law is constitutional. If it's not competent to the enacting body, then it is not constitutional. But then we're aware that, I mean, we're talking about human affairs, and those are by their very nature super dynamic, right? Something can touch on this and touch on that all at the same time, right? So the pith and substance doctrine says that in characterizing the legislation, all courts, right? Remember, these are doctrines and principles that the courts themselves have laid down over time to guide, you know, their duty, to guide them in discharging their duty of judicial review. So the pith and substance doctrine says that if the courts decide in reviewing a legislation, have determined the essence of this legislation, you know, using our example, is, in this case, conversely, regulation. It touches really on conservation, right? This is the Parliament really just trying to, you know, maintain the a healthy bio condition of our seas, right? But then, incidentally, it touches on, or it kind of curbs commercialization as well, right? To say that if you have harvested more than 8,000 tons of fish from a particular body of water for a year, please do not harvest anymore. It kind of touches on commercialization as well. But we're able to see that really the real essence of that legislation was really just to preserve and make sure that, you know, the sea is not harvested, you know, and cleaned out dry, right? So we see that, I mean, the essence of it really is conservation, but it touches on commercialization incidentally. So the pith and substance doctrine says that the fact that a legislation touches on another subject matter that is not competent to the enacting body, incidentally will not make that legislation unconstitutional. Does that sound good? When I'm explaining this to my candidates, I always use this bottle, my water bottle. So it is essentially a black, I guess, acrylic bottle, but then it has a white or silver metallic cap. But in all, I mean, if you were to describe it, you could say it's a black bottle, right? Now, so this is the regulation of Fisheries Act 2007, right? My bottle. Now, the courts have reviewed all the components and the features and the parts, and have held that substantially it's a black acrylic bottle, right? Designed to hold water. But so that the water doesn't lose steam or get contaminants, incidentally, we need a cap. Now, the cap cannot be black acrylic, right? We have to use a metallic cap, right? So, but I mean, it's just this portion of this entire bottle that is white. You won't describe this bottle as a white or metallic bottle, would you? It essentially is a black bottle, though it has a white cap. So the pith and substance doctrine says that even though my bottle has a white cap, for that, I mean, the fact that it has a white cap will not make it a white bottle. It will still be a black bottle, though with a white cap. Have I confused you more? Right? So it is still a legislation in relation to regulation, though it is incidentally curbs commercialization. Are we good? So my bottle will still be competent to the Parliament if, you know, black acrylic materials are competent to the Parliament. Does that make sense? Right? Even though this white cap is competent to the provinces and my bottle has a white cap, but because substantially the essence, the substance of it, at the core of it, right, or the larger part of it is black acrylic, then it will be competent to the Federal Parliament, who has the power to regulate black acrylic materials. Do you see that? Right. At the intensive classes, we'll review case laws when you review case laws, it makes it come out, it makes it animated and easier to understand. So that is pretty much the conversation on the pith and substance doctrine. And then we'll move quickly, because we're running out of time, quickly to the interjurisdictional immunity doctrine. These are doctrines, I've decided to spend a lot of time on them because these are doctrines that get candidates pretty mixed up. I mean, just from the explanation, you see that it can be confusing because there's some overlap. And I was going to zoom in on Anne, when Anne was, explaining her understanding of division of powers, you use the word exclusively. That's a conversation. I mean, you sounded to me like you had studied your materials, or you started to study your materials. Have you started to study your materials? Yes, but you have taken a look at it, right? Okay, so the word exclusively, fantastic, right? In Canada, division of powers, once we're able to determine that this subject matter is competent to this, level of government, then it is the exclusive reserve of that head of power. There are no overlaps. There's no covering the field, right? But we also need to be aware of the fact that there's some concurrences, right? There's some degree of concurrence that show up, in Canada's concept of division of powers. We'll get into that. It's very important that you get that clearly sorted out, because it could cause some confusion once you're trying to shelf your understanding of these principles. We'll get into that in very fine details at the intensive classes. We're almost out of time. So we move into the interjurisdictional immunity doctrine. Now, remember that the pith and substance doctrine says that, yes, determine the substance of the law and assign it, and you're good. However, in doing that, if you find that this law also incidentally touches on another subject matter that is not competent to the enacting body, if it is just incidental and minimal, then it's okay. That should not be enough to, invalidate the law. Now, the interjurisdictional immunity doctrine is almost, it's almost like the exception to the general rule of the pith and substance doctrine, right? The interjurisdictional immunity doctrine says that for certain entities, principally federally regulated undertakings and federally incorporated companies, take note here, right? FRUs and FICs, federally regulated undertakings, federally incorporated companies. In Canada, you can incorporate a company federally or provincially. If you incorporate it provincially, it means that you can only engage in business within that province. If you incorporate federally, it means that you're answerable to the federal government, right? And the advantage of that is that you can engage in business across all the provinces, right? So for federally incorporated companies, unlike provincially incorporated companies, they are not essentially, they're not bound by provincial, for instance, corporate laws. So for instance, in Ontario, you have the Ontario Business Corporation Act, and in Canada, you have the Canada Business Corporation Act. If I incorporate my company federally, I should pay closer attention to the CIPCA than I would pay to the OPCA, right? And and vice versa, if I incorporate my company provincially, then I would be paying more attention to the OPCA than I would be paying to the CIPCA, right? So I needed to highlight that for you to see how that dynamic will work when we start to review the interjurisdictional immunity doctrine, right? So the federal incorporated companies and the federally regulated undertakings. Federally regulated undertakings are pretty much undertakings that, due to the very nature of what they do, the business that they engage in, they cannot be regulated provincially, right? Fine example, case in point, to be telecommunications companies, right? The bulk of them cannot just, the bulk of them, they can, but the bulk of them eventually don't just provide network services to a province, right? It usually is, at the very least, a couple of provinces, or more often than Canada-wide, right? So for instance, Virgin, operates in Alberta, has masters, physical places of business in Alberta, but also has the same representations in all the other 9 provinces in Canada, right? Now, would you say that they should be bound by Alberta laws, just like they are bound by Ontario laws, and then Ontario says you can do this, but British Columbia says you cannot do this, and Manitoba says, oh, you must not do this? Do you see that, the very nature of the kind of service that they provide elevates them from provincial compartments, and places them on the federal level. So those are pretty much what federally regulated undertakings are. Transportation companies, telecommunication companies, and a couple of other things like that. So now, when a legislation particularly affects these two entities, federally incorporated companies and federally regulated companies, first of all, be clear. The fact that you're a federally regulated undertaking or federally incorporated company does not mean you are absolutely, completely, at all times immune to provincial legislations. No. If you transact business within these provinces, you are subject to the legislations within that province. However, in certain cases, to an extent, right, you can claim an immunity. I find that it's easier for you to understand these principles by just understanding the terms, right? Because, like I said, in Canada, the terms it's not like maybe in Nigeria where there's a lot of legalese, or in India where there's a lot of legalese, and then a term sounds one way, to a layman, but to lawyers is a completely different interpretation, right? With the legal concepts in Canada, they pretty much are named just as they sound. Interjurisdictional immunity, the fact that by my very nature, I operate, on an interjurisdictional level, right? I can claim certain immunities to a certain extent to the jurisdiction or to the powers of a particular province. Have I confused you? Are there questions, comments, or do I proceed?
Please, can you just summarize it again? Just, a little clearer. I have a little bit of confusion about it.
So, remember we're talking interjurisdictional immunity. And I've said that try to understand it the way that it sounds, right? So Semirat, for instance, you're Canadian citizen and you're Nigerian as well. So pretty much you're interjurisdictional, right? You are ordinarily subject to taxation laws in Nigeria and subject to taxation laws in Canada, right? But I mean, because of the sheer difficulty and sometimes impossibility of doing, being responsible to both jurisdictions, after a point, at a particular extent, you claim an immunity, maybe to Nigerian taxation system, to say, yes, I'm Nigerian, I'm subject to your laws, but for the purpose of taxation, I do not earn income in Nigeria, right? So I would rather be bound by Canadian taxation laws because this is where I earn my income from. Do you get that analogy? Right? So the fact that you're interjurisdictional, you're bound by both laws, right? Yes. But after a while, when it comes to certain things, you probably need to hands up and say, no, I need some help here. I need to be clear who I'm answerable to in certain, situations. Samirat, are you good? Are you distracted?
Yes, sorry, my daughter is here, but I'm listening.
I mean, with that analogy, right? I mean, doesn't fit on all fours with what we're talking about, but that's just to make it a bit simpler. So you bring that into a bell, for example, or virgin, right? The truth is that they are bound by laws across the provinces that they operate or that they engage in business. But when it comes to certain things, right, which we'll be reviewing, when it comes to certain things, they are able to go to the courts and challenge, the applicability of particular provincial legislations as it touches on them or as it affects them particularly, right? So another conversation we'll have is the fact that a judicial review of legislation on federal grounds usually takes three forms. It could be to the validity of the law, to the applicability of the law, or the probability of the law. I'm trying not to get that into this conversation so that we're not juggling too many things at the same time. Like I said, this is a very tricky and dicey area of constitutional law, and you need to sort it out carefully, right? So when we're talking about characterization and assignment, we're talking about how valid the law is. If the law was not enacted, even if the law is valid on the face of it, loosely speaking, if it was not enacted by the appropriate, level of government or by the legislative body that had the constitutional power to legislate in respect of that subject matter, then it is not valid, right? But for applicability, the law is valid. It has general application. It applies to everybody, But these two guys, federally regulated undertakings and federally incorporated companies, usually are the ones who make us have the conversation of interjurisdictional immunity. So they approach the courts and say, yes, we see this law is valid. Yes, we admit and acknowledge that we are, bound and subject to provincial laws ordinarily, right? But with respect to these particular provisions or this particular legislation, especially as it touches on us, as it affects us as federally regulated, entities, how far will these laws be applicable to us? Do you see that? So these are valid laws, these are applicable laws, but the federally regulated entities at some point and to an extent have an immunity that they can claim, for lack of a better word, to be immune or to immune themselves from the applicability of these otherwise valid provincial legislations. Now, remember, you guys have started studying. This is just an overview. This is supposed to give you a framework. When you start a study, or if you come for the intensive classes, and we have we break it down into finer details, and more importantly, review case laws, right? It will be animated, it will come to life, and you'll be clearer. But you need to be super careful. I mean, I've spent more than half of the time that we have for this session trying to explain this particular concepts, because I find that, first of all, they're the bulk of constitutional law. If you attend other tutors' sessions, they will say to you, constitutional law is divided into two: division of powers and charter. If you know division of powers and charter, you're good. That's not my approach. Largely, not because I'm criticizing other tutors, but largely because of the kind of questions I got in my exams, right? I got questions that were scattered across the syllabus. I mean, I mentioned to you that I got a question that asked me about the peculiarity of the Canadian federalism. If you structure your reading, or if your tutor structures his tutoring, in that division of power and charter, then you will not have zoomed in on that detail, because I had a 40-mark question, which was on division of powers, and then 10 6-mark questions that came out of all the possible places in the syllabus that you can imagine, right? So that has informed my decision not to start. I mean, it's easier to just say, we're doing division of powers and charter. I teach you division, I teach division of powers, I teach you charter, and you're good to go. But I mean, because of the kind of questions I got for my exams, I decided that, if I do decide to tutor people, I will try to zoom in on all the areas of all the aspects of the syllabus, because you never know. None of the tutors is on the exam questions formulating board of the National Committee of Accreditation, right? You never know, right? You never know. I mean, I didn't get a major charter question. I got maybe 2 or 3 6-mark charter questions, but I didn't get a major charter question. So imagine I'd spent all my time on charter and division of powers, you would have been stuck, because imagine 6-mark questions, they are hit or misses. It's either you know it or you don't know it, right? So, but when we get into the intensive classes, or when you start to study, in your personal space, and you're devoting time to this chapter, it will be clearer. Even if what I'm saying to you sounds like Greek, when you start to study, you will hear my voice in your head saying, oh, this is what she was saying. And then this video will be available on YouTube, I think. So if you run into any confusions, that is if you choose not to come for the intensive classes, you can refer to these videos or to this particular video, and then it probably make a bit more sense to you, right? So when you talk about interjurisdictional immunity, just know that you're not challenging the validity of a law. You admit, usually you, quote unquote, the challenger, the applicant, would be either a federally regulated undertaking or a federally incorporated company. And I'm giving you examples. Telecommunications company, aeronautical companies, airports, transportation companies that have operations across different provinces, right? And then they usually are the applicants to say, we see that this law is valid, we don't have a problem with the validity, we're not asking you to determine the character and right? We're just saying, yes, we agree that it is valid. Yes, we agree that the fact that we're federally regulated does not mean that we're never subject to provincial laws. But in this particular instance, right, are you sure, courts, that we should go ahead and have these provincial laws apply to us, right? So that's the conversation around interjurisdictional immunity. Jerry, you turned on your camera for, your microphone for a bit. Did you have a question or a comment or a thought? If not, right, if you do, you can jump in at any time. If not, then I move quickly to federal paramountcy. I believe that's chapter 5, but I like to take them together because those are 3 major doctrines that the courts have laid down that helps with judicial review of legislation on judicial review of legislation on federal grounds. Pith and substance doctrine, which I believe is pretty much clear to everybody on this call. Interjurisational immunity doctrine, which Samira still looks a bit puzzled about. You will get it when you start a study or when you come for the classes, right? And then federal paramountcy. This one is quite, it's a breeze. You shouldn't have any problems with federal paramountcy. Just as it sounds, federal paramountcy means that the parliament is paramount, such that in instances where, remember that we said that even though heads of powers are exclusive to, the levels of legislative bodies that sections 91 and 92 provide them to be competent to, right? Exclusive. I touched that because Anne kept using that word, right? But I also established the fact that there's some concurrence recorded, in the constitutional jurisprudence landscape of Canada, right? If you review sections 92, 94, 95 of the Constitution Act 1982, you will see that, clearly worded, expressly provided for certain subject matters are competent to both levels of government, both legislative bodies, parliament and legislative assemblies, right? Provincial legislative assemblies. So in the instance of concurrency, as well as double aspect matters, certain subject matters, just by their very inherent nature, have double aspects, just as it sounds. It could take on this aspect and it could take on that aspect. My example usually is road traffic offenses. I'm giving you that example here. It has 2 aspects. It could have a criminal, law aspect, and it could also have just regular traffic management aspect, right? Regular traffic management, which should be internal to a province, and the criminal aspect, which is competent to the federal government. So concurrencies that are recorded, even in the midst of the exclusivity that division of power preaches, right? And subject matters that are inherently inherently possess double aspects are 2 reasons why we have the conversation around federal paramountcy. And what federal paramountcy just says is that, or where it presents, is that there's 2 validly legislated enacted legislations in respect of a particular subject matter. The federal government has validly enacted the legislation in respect of this issue, and the provinces have also validly enacted the legislation in respect of this issue. Emphasis on validly, right? Both legislations are valid. The federal one is valid, the provincial one is valid, right? In Canada, there's the rule of perfect harmony. If both laws are validly enacted and they do not contradict one another, there's no conflict. What the courts have held is that, it's fine, there are no issues, go ahead and comply with both. Well, dual compliance is possible. Take note, against the backdrop of the fact that both legislations are validly enacted, right? If they're both validly enacted, then the court will say, go ahead and comply with both. That's the principle of dual compliance. However, federal paramountcy shows up where dual compliance is not possible. Because if you choose to comply with the federal one, you'll be contravening the provincial legislation. Or if you choose to comply with the provincial legislation, you'll be contravening the federal legislation, even though both were validly enacted and both are in respect of the same subject matter. So you're kind of in a fix, right? Or in the instance where, even though there is no express contradiction, in that particular situation, if you complied with the provincial legislation, you'll be frustrating the purpose of the federal parliament when the federal legislation was enacted. So express contradiction and frustration of federal purpose, right? If you have those 2, then the citizen or the applicant is in a fix. So the applicant will approach the court and say, there are 2 valid legislations in respect of this issue. I've tried dual compliance, it's not possible, and I'm confused. What do I do, right? And then the courts have developed and created the doctrine of federal paramountcy, which pretty much says that in those instances, the federal law takes paramountcy over the provincial laws. Are we good? That's it. That's federal paramountcy in 2 lines, where there are 2 conflicting but validly enacted legislations. The federal legislation would supersede the provincial legislation. There are a few other things, conversations to have around federal paramountcy that I'm not sure that we have the time to get into now. If you come into the intensive classes, we'll review case laws, right? And then we'll review the appropriate lingo to use when you're having the conversation, generally around judicial review of legislations on federal grounds. Remember, I said there's validity, there's applicability, and there's operability. So the conversation around federal paramountcy touches on operability. It's valid, both legislations are valid, both legislations apply to you, right? But which one should be in operation? Which one should you work with? Because dual compliance is not possible. Remember, I said, well, dual compliance is possible. The courts will, uphold both laws and say to the applicants, go and comply with both, even if it imposes a more onerous burden on you. So long as there's no conflict and you can comply with both, go and dually comply, right? But if there's a conflict or there'll be a frustration of the intention of the parliament, then the court will activate the doctrine of federal paramountcy and not strike out or strike down the provincial legislation, but the provincial legislation will just kind of go into abatement, right, for the federal legislation to become operable or to be the operable legislation in that instance. Are we good? Okay, so I'll run really quickly through the rest of, or I'll just touch light, I think, chapter 5. Okay, we've touched on chapter 5. Chapter 5 is paramountcy. I think from 6 to about, just 1 minute, let me take a look at my syllabus. From chapter 6 to about chapter 9 are just heads of powers, right? Heads of powers that the NCA considered important for us to review, right? Sometimes candidates get confused and, it feels like those heads of powers should have been reviewed before we now come into the conversation of how the courts, conducts judicial review. But really, that's just what it is. You know how the court conducts judicial review. And we've seen how a legislation, after characterizing it, the courts have over time expanded and expatiated on the meanings or, the interpretations of these heads of powers. What exactly does criminal law entail, right? What is the scope of criminal law? What can come and validly come under criminal law and what cannot, right? What exactly is property and civil rights, right? Does it just include rights with regards to real and personal properties, right? So those chapters just underscore a plethora of case laws, well, important ones, where the courts have made very well-reasoned and important pronouncement as to the interpretation that should be given those heads of powers. So you have criminal law, you have property and civil rights, you have POGG, and I think there's one other one, right? Those are the ones that the handful that the NCA decided that they would have us review in better detail. Doesn't mean those are the only heads of powers. Doesn't mean those are the only head of powers you will get in your exam hall, right? Or you could get in your exam hall. But these are the ones that the NCA wanted us to review, which, we'll review at the intensive classes, consider case law, see the conflict. There's a bit of overlap. There's a bit of contradicting decisions, authorities, but we'll review all of those trade and commerce vis-a-vis property and civil rights, POGG vis-a-vis property and civil rights. We'll compare, do the comparison, got the contrasting, and hopefully we're able to sort them out and compartmentalize them properly, right? So because you need to have a good understanding of those heads of powers for you to be able to, conduct your judicial review on federal grounds for the validity of a law, right? Because after you've determined the character of a law, you might go under sections 91 and 92 and not see anything that looks like what you have determined to be the substance of that law, right? But an in-depth understanding of the heads of powers will let you know that, okay, regulation falls under POGG, or conservation, right? Regulation and conservation of natural resources falls under, or has been held by the court to be a part of, such and such head of powers. Because sometimes after characterizing your law, for instance, you hold that the law is in relation to childcare or something. You go under sections 91 and 92, you don't see childcare anywhere there, right? So it's important that you understand and review those heads of powers to know how expansively the courts have interpreted them, what can be accommodated under what head of power and what cannot be, right? If you ask me, I'll say we should move real quickly to the charter rights because we have barely 20 minutes left on this call, right? And then I'll try to do one-liners on a few of the other topics before we go into the charter rights. So you have the language right, and language right is pretty succinct. All you need to pay attention to, is remember that from chapter 10, we're now we've moved away from division of powers. We're now reviewing rights and freedoms. What rights and freedoms, are protected and are provided for by the Constitution and protected by the Constitution. So there's the language right in Canada. We realize, or we appreciate the fact that Canada is a bilingual state, and then that brings up the conversation, or that makes it important to have conversations around, language rights. What is the obligation of the government when it comes to language, or the language rights of people, or of the citizenry, right? Off the top of my head, you need to know that the federal government is obligated or discharge its services, whether it's enacting law, it is programs. The federal government must discharge its services in both languages, English and French language, right? Certain provinces also have a constitutional obligation, which pretty much is nothing serious. It's just a function of what negotiations, they got into at the time of joining, at the time that territory was joining the domain of Canada to become a province. So certain provinces also, have a constitutional obligation to discharge services, in both languages, to make services available, to enact laws in both languages, French and English. Off the top of my head, Quebec, Manitoba, they cannot enact laws in just English language or in just French languages. They have to. Not all provinces have that constitutional requirement. They might choose to do it, but it's not a constitutional obligation. And you need to appreciate the fact that when it's a constitutional obligation and you fail or you're in breach of it, then the consequences are weightier than when it's just something that you chose to do as a province, right? And then we also underscore the issue of protection of minority rights. So, for instance, Alberta has a majority of English speakers, right? What protection will the minority French speakers, be entitled to, right? So those are things that you should pay attention to when you're studying that chapter. I believe that's chapter 10, language rights. And those are conversations we will have in better details, at the intensive classes. Chapter 11, Aboriginal and treaty rights, we've established here that the Constitutional Act 1982 ingrained or entrenched Aboriginal rights into the Constitution of Canada, and made Aboriginal rights have or assume constitutional status. So in reviewing that chapter, we'll trace a bit of history, right? The relationship between Aboriginal people and the government of Canada, what they have been through, where they're at, and the import or the effects of the fact that Section 35 of the Constitutional Act 1982 now makes Aboriginal rights a constitutionally protected and guaranteed right, right? Off the top of your head, that means that it's no longer, out of the benevolence of the government. It's now a constitutional obligation that the government has to discharge when it is dealing with Aboriginal people. So those are some of the conversations that we'll have, in better details at the intensive classes. Then chapter 12, we're looking at interpreting the Charter of Rights. We'll be looking at, that as principles of judicial interpretation, right? what principles of the court, some of them we've highlighted in our conversation thus far, but more importantly, we'll be looking at, principles like the progressive principles, the progressive principle of judicial interpretation, to say that, these rights, even though they were provided for in 1982, are not stuck in time, right? Are not frozen in time. We're looking at the living tree approach to say that, yes, the Constitutional Act is dated 1982, and that's the document that provides for these rights. But we realize that as we advance as a people, right, as we evolve, some of these rights also need to be evolve, and it's not necessary in all circumstances that the government has to sit down to amend the Constitution. Sometimes the fact that the court has that leeway, right, that duty, that power to interpret these laws can accommodate this evolution and this advancement. Do you see that? So we're looking at the progressive interpretation, we're looking at the living tree approach, we're looking at, interpreting the provision of the Charter in the spirit, in accordance with the spirit of the Charter, not just the letter of the Charter, but understanding that the Charter was created for a certain reason, right? To guarantee civil liberties, to ensure, a basic decency of human life, right? And then that also should be a factor that the court will pay very serious consideration to, serious attention to, in interpreting the provisions of the Charter, right? Pretty much with chapter 12, we get into all that detail at the intensive classes. Chapter 13, application of the Charter of Rights and Freedoms. I like to approach that with my candidates as dividing it into the burden of the right and the benefit of the right. Who enjoys the benefits of the Charter rights, and who bears the burden of the Charter right? A mouthful, very interesting conversation to have there, in that chapter. Pay attention to the use of words like individual, everyone. What do they connote? What do they mean? How do they impact, who can claim a protection that is made available by a Charter right, right? Who does the Charter apply to? Who bears the burden of the Charter, of implementing the Charter right, of ensuring that those Charter rights are protected? Is the Charter applicable to private citizens in terms of burden? Of course, private citizens enjoy the benefits, right? So the Charter is applicable to private citizens in terms of the benefit, but is the Charter applicable to private citizens in terms of bearing the burden of giving effect to the Charter rights? Right, those are conversations that will have very important chapter. Pay very serious attention to it if you choose to self-study, right? And then 14, overrides of right, pretty much just, the conversation to have there is that section 33 of the Constitution Act provides that, the government, the federal government, has the powers to enact laws. In fact, both the federal and provincial government have the powers to enact laws that override the provisions of the Constitution, right? We'll look at, that in better detail. What are the dynamics of that provision? When will it apply? When will it not apply? What is the scope of its application, right? Because you remember that we've established, we read section 52 of the Constitutional Act that says that any law that is not consistent with the Constitution is null and of no effect. Now, section 33 provides a power that allows the government to enact laws that, are pretty much not consistent with the Constitution, right? So that's like a contradiction going on there. But remember, they're both contained in the Constitution. So it's not a function of which is more superior. They both have constitutional effect or status. We just need to underscore the interaction of, section 52 and section 33, right? What's the scope? What are the requirements, what are the things that the government needs to put in place for section 33 to come into effect, right? So that's conversation to have on chapter 14. Chapter 15, limitation of the right. If we had a bit more time, I would have invited someone to read section 1 of the Constitution Act 1982. We will certainly read it at the intensive classes. If you read section 1 of the Constitution Act 1982, you see that it provides for the rights, it provides, guarantees, but also limits the rights, right? So those rights are constitutionally guaranteed, but are not absolute, right? In certain situations, they can be breached, constitutionally breached, right? Which is why you still have, you know, the criminal code in Canada that provides jail term sentences, right? So those rights can be breached. When can they be breached? How should they be breached? What does the court come up with as guidelines to help determine which breaches, which infractions are justifiable, right? Those are the things that we'll be looking at in under that chapter, limitation right. We'll be reviewing R and Oaks, the case in very fine details, you know, very important case, and just evaluating the operation or the intermingling of the case of R and Oaks and Section 1 of the Constitution Act 1982. Okay, so chapter 16. Okay, so chapter 16 to 19, we start to review the charter rights. Very important section of the, or portion of the syllabus. Very important. We're out of time, so what I would say to you is, of course, if you come to the intensive classes, we'll review them, review the case laws, review how to establish the rights as the applicant who's claiming that my charter right has been infringed, and how the government or the other stakeholder, the other player who's infringing your rights can justifiably demonstrate, you know, the validity of that infringement or that breach, right? But what I'll say to you as a tip, if you choose to self-study with regard to chapters 16 to 19, free tip on the house, right, is have at the back of your mind that each of those rights have a test. So glean out the test for establishing those rights from your study, right? Glean them out. So for each of the rights, have the test, you know, written down next to it. And then the limitation is omnibus. It's the same one limitation, you know, that was laid down in R versus Oaks, contained in Section 1 of the Constitution Act 1982 that applies to all the acts. I mean, all the rights, I beg your pardon. But the test for the rights are different, and you need to glean them out from your own study, right? If an applicant is claiming that his rights, equality rights have been breached, what does that applicant need to establish? What does that applicant need to convince the court about, right, to be able to benefit from that protection, right? To be able to get the court to agree that, oh yes, you had this right. Oh yes, your this protection, the protection that this section of the charter provides for, you are eligible to that protection, right? And then we also see that it has been breached, right? Also pay attention to the burden of proof, the oscillating burden of proof when it comes to charter rights, how it oscillates, you know, first from the applicant, next to usually the governmental actor, right? I mean, we don't have a lot of time to get into those rights, but pay attention. I mean, I've said to you that some tutors base off their entire session on just division of powers and charter, split the entire syllabus into two. So that tells you that, you know, it's important, and there's a whole mouthful, you know, to review when you're looking at 16 to 19, section 16 to 19. Now, for remedies, real quickly, as it sounds, we've gone through the process of division of power review on federal grounds, you know, with respect to a legislation, and we've gone through the process of judicial review on charter grounds with respect to the breach or infractions on charter rights. Now, the court has agreed with whoever the applicant is that, for instance, this legislation is not constitutional, or this action, right, you know, is not constitutional, or you suffered a wrong, really, or your constitutional right was breached, in fact, right? Now, how does the court tidy up? How does the court address the grievance that has been created, right? For federal grounds, judicial review on federal grounds is pretty, I mean, it's not as straightforward as it sounds, but it's pretty straightforward, you know. And the basis for that, the bedrock for the remedies that the courts will pronounce when it comes to judicial review on federal grounds of legislation is Section 52 of the Constitution Act 1982, which we read on this call. Any law that is inconsistent with the Constitution, right, is null and of no effect because the Constitution is the supreme law of Canada. Are we good, right? So Section 52 speaks to that in terms of remedy, in terms of judicial review on federal ground. There's a whole lot of different forms and shapes that declaration of nullity can take, right? About 6 to 8 of them, right, that you need to pay attention to, that we'll be reviewing in class, right? And then we move to remedies in terms of the charter, in terms of a charter breach. And for that, you should be looking at Section 24. Read Section 24, review case laws, right, and see, you know, the scope of the court's jurisdiction when it comes to remedying a charter breach, right? How far they can go and, you know, how far they cannot go, and, you know, how creative the courts have become, you know, in trying to remedy charter breaches, right? Are we good? I think we were able to touch on all the chapters of constitutional law, albeit some we did a sprint, some we did a merry-go-round, but at least, you know, when you pick up your books, it sounds familiar. And don't feel too bad if you, I mean, we certainly cannot compress constitutional law. I mean, maybe next to foundations is probably one of the most bulky of the NCA courses. And it's not just bulky in terms of volume, like, you know, maybe a criminal law that can be a page turner, is fun, is interesting, or he killed his stepmother, blah, 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 what is going to happen. For constitutional law, you have to be very introspective and you have to engage your critical mind when you're reading, because there are a lot of chunky concepts that you need to understand and that can overlap. So you're at a risk of some confusion, right? You're at a risk of setting up your shelf in your mind. Oh, I understand this, I understand that, and you see a question or you get somebody asks you, so what is this? And then you feel empty, like, oh, I thought I knew that, but I mean, now I'm not exactly sure. So don't feel too bad if it's your first exposure to it and sound like Greek, right? Especially IJI, Semirat, right? When you start to study, right, it will be clearer. When you start to review case laws, it will be clearer. And certainly if you take on my intensive classes, we will sleep on those concepts, right, until you get them, right? Right, so yeah, once again, thank you so much for giving us a slice of your time. Hopefully we made it worth it, right? And again, let me reiterate before we go. If you have a question or you just want to reach out to me, scun@ncaaguides.com. Our intensive classes are starting next week, I think, right? If you decide that you need some help or you want to be a part of it, it'd be great to have you. In fact, I look forward to seeing you guys at the intensive classes, right? Any questions, thoughts before we go? Right? Questions? Are we good to go? Hopefully you are fired up to go and read and you're not scared to go and study. It's just a bulky course, right? But it's fun. And I mean, approach it with the mindset of the fact that you have underscored the constitutional jurisprudence of a jurisdiction before, right? So it's just pretty much the same thing. It's just that, you know, we're doing that for Canada now. So everything you read, try to find its space in the landscape, right, of the constitutional jurisprudence of Canada. That's all it is. Don't have random, disconnected understanding of concepts. Everything you study, everything you read or you get an understanding of, try to tie back into how it fits, you know, constitutional law. Why are we studying this in this course, right? And you'd be good, right? Okay. Thank you so much, guys. Particularly Ife and Semirat, Naomi, Binky.
Thank you.
Guys at least.
Thank you.
Spoke right
very
back at me. So thank you, guys. Thank you.
you.
Thank you.
Yeah, bye.
Bye.
Bye-bye.
Bye.